What is joint tenancy, and why can it sometimes cause unintentional disinheritance? Most husband and wives own property as joint tenants or tenants by the entireties. This simply means when one spouse passes away, the property automatically transfers the property to the surviving spouse. But perhaps you own property as joint tenant with someone other than a spouse. That means if you pass away, that property automatically goes to them, not necessarily who you designate in the will. For example, let's say there's Bob and Sue. Bob and Sue have 3 kids, but Sue suddenly passes away. The kids grow older, move out of the house, go to college, have lives of their own, and then Bob meets Sylvia and gets remarried. Let's say Bob's been in the house for 30 years and it's time for some remodeling. He goes to refinance the house to get a home equity loan to fix the kitchen and is told by the bank that Sylvia has to be on the loan. Well, Sylvia, of course, says, well, if I'm going to be on the loan, I want to be on the deed as well. Then Bob passes away. Who gets the house? Since it's in joint tenancy, it goes to Sylvia. But wait a minute. What if Bob had a will, and that will stated that the house is supposed to go to Bob's kids? Well, that will doesn't control assets owned by joint tenancy. So Sylvia, in fact, gets the house, and Bob's children would receive nothing. To avoid this problem with joint tenancy, you have to look and see how assets are titled. You need to make sure that you either have proper beneficiary designations or put the house into a trust to ensure that while Sylvia's rights are protected if she would survive you, it also ensures that Bob's share would go to Bob's children, not to Sylvia. For additional information on other topics regarding estate planning, please call us at 1-800-879-0984, or you can visit us on the web at www.shieldsandboris.com. The elder law offices of Shields and Boris, helping you protect your family legacy.